Hi, friends. Welcome back. My name is Carly Jones, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I wanted to come on the channel and make a video following up on commonly used legal terms that employment attorneys just kind of throw around, and attorneys in general just kind of throw these terms around. And we expect that our clients know, or sometimes we just forget that our clients didn't go to law school with us and they didn't learn all of the same terms that we know. And so I've already made videos about this before. And so I know there's a lot more terms. And if there are terms that I miss or terms that you have questions on, please feel free to post a comment and ask me a question. I'll make a video response giving you a reply as soon as I get the chance. There's no question that's like too stupid, too dumb, or too wild, far fetched within the scope of employment law. It can be a very niche field. And then there's also the legal field in general can be kind of a snobby, prestigious field at times. And so sometimes we like to use terms and use language to show off our knowledge and try to intimidate the other side. So today I'm going to break down some legal terms. I want to get started with something that lawyers, these are terms that are used interchangeably: lawsuit and complaint. So in a previous video, when I've talked about common legal terms, I've talked about the difference between criminal court and civil court, and the fact that when we are talking about employment suits, we are talking about litigation in civil court, so civil litigation. And not to say that there aren't crimes that happen within employment litigation, but a crime is a situation that's reported to the police, and it's a situation that the police have decided to follow up on and press charges, and is attached to criminal law, is attached to jail time, sometimes some monetary fines, but primarily it's attached to jail time, whereas civil court, it's not attached to jail time. It's primarily attached to money judgments or ordering someone to do something or to stop doing something, like restraining orders or injunctions and stuff like that. An injunction is an order that a judge makes that, again, stops a business or an individual from doing something, or it requires them to do something. So, for example, you could have an injunction to stop your neighbors from throwing a party every single weekend at their house that lasts until 5 in the morning. Maybe for that situation, you might want to get a restraining order, though. A restraining order is the same thing as a preliminary injunction, an injunction, but a restraining order is something that is more emergent. We like need the order right away. And so usually the same day that you file a restraining order, you may be heard in court or like within a short period after that. And it doesn't require the other party who you're getting the restraining order against to be present in court when that happens, whereas an injunction does require it. A restraining order is going to last a shorter amount of time, again, because we've had a full judgment and hearing without a party being present, a required party being present. So they're going to be shorter lasting in time and have some different procedural maneuvers than a preliminary injunction, where you have to go more through the official court system. But a preliminary injunction is likely more permanent. It's going to be longer lasting. So if you want to know more about the difference between restraining orders and preliminary injunctions, or just more about those terms in general, again, feel free to leave a comment and I will make another video. But that's not what we're going to be talking about today. Now that I've reviewed the difference between criminal law and civil law, and that criminal law, we talk about charges, like we're charging someone with a crime. And then in civil law, we talk about a complaint, or we talk about filing claims. And so not charges. So one of the things that attorneys mix up a lot, these terms that attorneys throw out there and then mix up a lot, are lawsuit and complaint. When we're talking about civil complaints, a lawsuit and a complaint, it's the same thing. So when you file the piece of paper that says this is what happened and we say this law was broken and we demand this much, that is the complaint. Again, it's also called a lawsuit. It's also maybe referred to as a case. The thing about complaints, lawsuits, they have to be well pleaded on their face, or else you could have your whole lawsuit dismissed before it even gets started. And so a well pleaded complaint will, again, like state the facts which bring the claim to us. It will also state the laws that they believe were violated and what kind of recovery is sought to make the situation whole. So that a lawsuit, that's a complaint. Complaints have to be well pleaded. And another term I wanted to talk to y'all today about is stipulation. Attorneys will say stipulation all of the time. And I promise you, even law students are like, wait, what? What is that? Because it's just a term that gets used a lot. And so it sounds very official. And then it's like, but wait, What does that actually mean? So a stipulation is just an agreement. It's an agreement between two parties, the party that's suing and then the party that's defending themselves, the plaintiff and the defendant, and they come to an agreement about things that they're just not going to argue about. So, for example, in a car accident situation, the parties may stipulate to the fact that it was raining on the day that the car accident took place. And like, why would we need to stipulate about that? Well, if we're claiming that someone ran a red light and then they caused a car accident, perhaps the fact that it was raining profusely is going to increase or decrease liability. So someone may want to like argue that it was raining. Someone will be like, no, it was just a light sprinkle. It wasn't that bad. Like that didn't interrupt the driver at all. He was still being negligent. So they may not want to agree on the weather that day. Also, though, the reason we may stipulate and agree that the weather was raining profusely that day, the reason we would want to stipulate about the rain is because it's going to either increase or decrease the driver's liability. And also, the reason why we may need to like stipulate and just say we're not going to argue about it is because we have the news, we have the weather.com, like we have all of these various reports that say it was raining profusely at that exact place at that exact time that the car accident took place. In an employment suit litigation context, for example, the parties may stipulate that the person was fired and that they didn't quit and that they weren't constructively terminated. They actually were fired. Or the parties may stipulate that the defendant was actually the boss of the plaintiff. And so we're not saying that the boss sexually harassed the plaintiff, but we will agree, yes, we stipulate that was the boss and the plaintiff was the superior. So a stipulation is literally just an agreement. It's an agreement that both sides on the opposite side of the lawsuit come together and say, we are not going to argue about X. Something else I wanted to talk to y'all about today was the mediation versus arbitration. Mediation occurs when both parties come together. They hire a third party, a neutral third party who's going to come and mediate back and forth between each room. And the parties come together with the mediator. Each party has, side of the lawsuit has submitted some kind of a brief or some kind of documentation telling the mediator, updating them on like what the case is and what we're each claiming. Then we come together and the mediator goes back and forth between the rooms and tries to get the parties to come to an agreement on how to settle or resolve the case that day. Sometimes mediation can last multiple times, like multiple days. You'll go in for a day and then it didn't get resolved, but another mediation session would be helpful. Sometimes it's just a short period of time and then months later, you might have another one or you might not, and you'll just move forward to the next step of the lawsuit. But it's an opportunity, regardless of if you settle or if you don't settle, it's an opportunity really to like learn about the other side and where each other is at in the lawsuit. So it's always a good thing to go to mediation, in my opinion. Arbitration is basically the same as mediation, but the difference is that the arbitrator basically becomes the judge. And instead of a mediator, we have an arbitrator. And then the arbitrator, instead of just mediating between both sides and trying to help negotiate between the two parties to come to an agreement, the arbitrator is responsible for actually making the case resolve and come to a conclusion. And so the arbitrator kind of becomes the judge in the sense that if the parties don't agree, it doesn't matter. What the arbitrator says goes. And so the parties will come together, the arbitrator will learn both sides of the case, they'll hear different evidence and arguments, and then they will come to a decision. And whatever the arbitrator decides is pretty much binding. Of course, there are always exceptions and rules and ways in which an arbitration agreement may not be upheld in court, but 9 times out of 10, it's going to be upheld. There has to be some like very unconscionable or egregious behavior for an arbitration agreement to not be held up in court. So mediation is kind of an optional way to negotiate and settle the claim. Arbitration is usually a like closed case. We are solving the case today. Arbitration agreements are typically in employment contracts. And so that's something to always look out for when you're signing an employment contract. And in general, I don't necessarily think they're a bad thing, but just when they're forced on a person, that's not good. Like force being in an employment contract, meaning if you don't sign this arbitration agreement, then you don't get hired. And an arbitration agreement is signing away your rights, right? It's saying that if we come to a legal dispute, then we're not going to have the opportunity to necessarily mediate. We're going to go to arbitration and we won't go to court, which means I won't be able to tell a jury of my peers what you have done to me. I'll make a different video about talking more in depth about the difference between arbitration and mediation and the positive and negatives. So if you're more interested in that, take a look at that video. And if between this video and that video, I haven't done a good enough job of explaining, or you still have questions, please post a comment, let me know, and I will explain more, talk about it more, because it's a heavily used area in employment law. You will likely hear the terms mediation and arbitration, if not once, multiple times throughout your employment litigation suit process. The other term I wanted to talk to y'all a little bit about today is deposition. So a deposition is a part of a discovery tool. I have another video about the stages of a lawsuit. And so if you don't know necessarily like the timeline or the progress and how the process of a lawsuit, an employment lawsuit occurs, please go back, take a look at that video. But deposition is part of the discovery process. It's a discovery tool. So after we've gone through filing a lawsuit and mediating and trying to negotiate and we haven't been able to settle, and it's looking like we're maybe going to have to take this case to trial, we will start into the discovery process. Discovery is the process of basically exchanging evidence and gathering evidence to better prepare yourselves for trial. When people walk into a lawsuit and they go to trial, when we walk into trial, we walk in with an open book essentially, and each side pretty much knows what the other side has on them and like their strategy and who the witnesses are going to be called and like generally, essentially the questions that are going to be asked. And the reason we know that is because we've gone through the deposition. And so a deposition is kind of like a mock trial, a little bit. It's not literally, it's not technically, but just basically. It's basically a mock trial without a jury and without a judge. So all of the witnesses or like most of the witnesses, the key witnesses, the most important witnesses to a case are going to be called most likely and questioned at length. The deposition is going to be recorded. So all of that questioning is going to be video recorded. There will be a court reporter there as well. So there will be transcripts, and both sides get to ask as many questions as they want. And the really intense thing about a deposition is that you can't object. I mean, you can object and make a note for the record that there will be an objection if this goes to court. But because there's no judge in the room, there's no one to make a judgment on these objections or not. And so in a deposition setting, really any question goes and you can object, but then the person still pretty much has to answer. So a lot of information can come out during a deposition. And again, it's all under oath. You're sworn in and everything, each person who testifies. And so any statement that you say that is a lie or a non-truth or any kind of obstruction of justice, you can be held liable. You can be held in contempt and have to go to jail or serve fines for lying. So it's high stakes, it's highly expensive, but it's a great opportunity to like learn a lot about the other side and give them a taste of like what's coming down the pike for this lawsuit if it were to progress to trial. So that's what a deposition is. The last term that I want to go through with y'all today is interrogatory. An interrogatory is another discovery tool. So it's another way that we gain and gather and share whatever evidence throughout the discovery process. And an interrogatory is really just like a written question with a required response. So instead of a deposition is in person, there's video recorders, there's court reporters, you're sworn in, and obviously again you're answering in person. It's an in-person Q&A, an interrogation session. So you can see someone's body language, you can play off of that and kind of like use that to your advantage. In an interrogatory, it's just a written question and answer. So an attorney writes a bunch of questions that they want answered, they send it to the other side, and then the other side is required to answer those questions. Again, truthfully, they're not sworn in anything, but it's still, these are permanent records that will exist throughout the lawsuit. I hope that this was helpful, and I hope that this was informative and empowering, and that in one way or another, it helps you get paid. If you appreciated this video, found it helpful, or like enjoyed this content, want more, please let me know that as well. Give me a comment, a like, a share, and I'll see you next time. Remember, everybody works, but not everyone is safe at work, and I'm trying to make sure that y'all know the difference. Okay, have a good day. Bye, y'all.